Hearsay is information received from other people that one cannot adequately substantiate. It's rumor. It's similar to heresy, which is the holding of religious beliefs opposed to church doctrine. It's a belief or opinion opposed to a generally accepted view. The legal fiction is a fact assumed or created by courts, which is then used in order to help reach a decision or to apply a legal rule. The concept is used almost exclusively in common law jurisdictions, particularly in England and Wales. So here's the difference. These are used as synonyms, but they are not equal nor the same. A testimony is a formal written or spoken statement, especially one given in a court of law by a man or woman who has lived, and they know that information because it's a testimony of their life, a firsthand account. An affidavit is a written statement confirmed by oath or affirmation for use as evidence in court by a man or a woman acting in a position of power that actually then means if you need to have your words verified by someone involved in the fiction or fraud, then your word is not enough. Your word is not your bond, and that is dangerous territory to stand on. Here is where we start to see that common law is the unwritten and unlimited law unless changed and converted into limitations based on what's conveyed in the written form. So there are three forms of capitis diminutio, maxima, media, and minima. I didn't realize media is also a minor, which is a minor that you go in and mine the land and you are worked by the system, or is it mined? You are mined when you are a minor. So, minima is based on a change of status in your family. So, it's consisted of a person ceasing to belong to the agnatic family related on the father's side without loss of liberty or citizenship. So, when you marry, you change your name, for instance. But sui juris or sui juris is of age or independent, whereas alieni juris is under the control of another as a lunatic or infant. So these, we are born to our families and we are wards. They are our guardians because they have the right to speak for us until we are of age of majority, and then we have the vote or right to vote for ourselves, which is another thing altogether, given that if you vote for a representative to speak for you, then you don't have the final vote in your area no longer. Media is the minor version of loss of status, consisting of a loss of citizenship and family without any forfeiture of personal liberty. I believe that the media have been used to actually kick the ones that do not believe the same narrative out of the tribe, because the tribe has always been used to keep the individual in line. And then the ones who are the fringe dwellers, which fringe minority is actually a status that is owned by the creator of the status. So I wouldn't recommend accepting that status either, because that's dangerous territory. If you become a creation owned by a creator that has already imposed bylaws that are not in anyone's best interest. And then maxima, capitis diminutio maxima, involved the loss of liberty, citizenship, and family, being made a slave or prisoner of war. Slavery is said to be illegal. However, if our person is made to be bound to corporate legislation and mandates that actually go against higher level constitutions and charters, then how are we going to actually call anything to account if we have lost it all and are in the belly of the beast and then have to get ourselves out of the trap which we are in alone? And when we are at the hands of ones that don't understand or believe what we believe, it is very difficult to prove our own sanity, which I experienced firsthand, and why I share that the OPCA litigant status conversion threat is very real. And I do share how I came into that uncommon insight in Fully Committed. Here's what you need to know. There is a man that is known as Justice Rourke that scripted the Meads versus Meads case law precedent that means if you use a freeman of the land argument or a common law argument, you can be deemed a vexatious litigant because the legal profession will always draw on case law precedents from the past in order to say why that happened last time and it was a good result for you to be subjected to too. And I say, no. Vexatious is an adjective meaning causing or tending to cause annoyance, frustration, or worry. And if you are purporting an alternative story to what the mainstream media, being a medium diminishing of capacity, that's dangerous. If you don't know how to not consent to the application of a status that would actually draw you into the public, where you would be hiding your privates, trying to say that you are standing on common law when you need to also know how to claim your right to stand in your private capacity with all common law rights reserved at all times via lawful notice, that you then stand on the claims made in written form. These are the things that you can do if you know how to do it. Know who and whose you are. This is not a competition. We all come from the same source. We all return to the same source when our life force is used up and we go back where we came from and reflect on everything that we did while we were here, which is why I will stand in my private capacity. And my claim is that I am a woman in my private capacity with all common law rights reserved at all times. So any man or woman who claims otherwise must make a claim in a court of competent jurisdiction, which does not include legalese, which I am not versed in nor competent in. Any man or woman who claims otherwise must make a claim in a court of competent jurisdiction that can provide an unbiased judge or jury to hear the matter. If the man or woman sitting on the bench passing judgment on my case is getting paid by the same corporation that the man prosecuting my case is getting paid by, how is that fair? And how am I going to get an unbiased trial where they will try all because they are colluding together to convict an innocent woman who is convicted of my beliefs? Conviction. Viction is a calling. Did you know? I do not consent to the application of any title, status, or personage. I claim addressing me otherwise is fraud, and all men or women are on notice in their private capacity in the charge against my person. They have never gained jurisdiction over, are trying to move a false claim against me based on the power of notices. This is the definition by Merriam-Webster, which you'll notice it says compared to here, because when you make a notice, you don't reference their legislation, the corporate legislation, as if that was the extent of what you have access to. It's simply to remind them that you are aware of the limits of where they can go. And then you put compared to or CF, which is short for the Latin word confer, and instructs the reader to compare one thing to another. So this is not the limits of what a notice can do, but it is the definition that I can reference and say compared to the condition of being warned or notified. All men and women are on notice in their private capacity that I will not allow any suit to be worn to protect the man trying to take the boot to me, the woman, because I have claimed my status and not had it contested. So the power of notices, the reason I can speak with such conviction or with such fiction is because when I got locked up under the Mental Health Act, I was claiming to be what I am now doing because I learned this because of that. I just tuned into this version of me then before I had context or experience to be able to do it, which sounds crazy. But crazy by definition is different. And sometimes we just know things, which is called claircognizant. Clairsentience is clear sensing, clear feeling. Clear audio is clear hearing. You just hear things and it's like, oh, where did that come from? Am I going crazy? No. You're an energetic being. You are a channel. You are dialed in to the source that we all come from, and you just forgot. Clear visual is seeing things clearly in your mind's eye. Sometimes that happens too. And you can't deny it because then you get to experience it later and you call that deja vu. That's the spiritual element of this. And what we must start to realize is that when you're talking to people who are fixated and focused on the 3D, which is the literal reality that we live in, when you talk about the symbolic, mythic, and energetic layers that are all happening simultaneously, it sounds insane. It sounds like a competing reality, which is where a psychotic episode can come from. If you're talking about a different reality than what they can see because of their limited perspective, not factoring in the higher level energetics behind what we see, there is a relatability issue. They can't relate, they can't connect. It's not, you're not safe to them. So then they'll shut down. They'll close off. Their fight, flight, freeze, fawn, fornicate mechanism within will say, whoa, okay, no, compared to when we actually make the information safe because we say, take this at your own pace. It's a lot of information coming at you. And I don't expect you to be impressed with this. What I hope is that you will be able to express what it means to you, what it means for you, and what you're going to do with it, and where your questions lie. Because when you ask questions, asking is how you become as king in your reality. To act honorably in good faith, you must give notice ahead of time. Ahead, when you get capitalized on, the head of the I disappears and you get boxed in top and bottom. Think of it. And then feel into the resonance of truth that I just shared. Let another man or woman know you believe a trespass has occurred via lawful notice in written form. You give them time to respond. Unrebutted claims stand as true, and your notices are evidence you've acted honorably in your dealings by seeking lawful remedy. Hey, we've got a problem. I'm notifying you of it via notice. I'm mailing it to you or emailing it to you, and I've got proof of that because I've saved it. I'm building my case in these notices that I'm sending you and expecting you to respond to. Because a claim can be made against the man or woman causing you harm, loss, or fraud that is heard in a superior court of competent jurisdiction where men and women face off and the suits have to be taken off. For we only put on the suits in order to act so that we can pay for the life. In fact, we take the suit off in order to be able to go and enjoy. Yet, if there is no liability insurance, that umbrella will protect the man and woman acting until it doesn't, and it won't always, which is the insanity of why we need to wake up before it's too late. And we do that by actually putting a date on it, literally on your notice, which we're going to get into in the next page. But the I on the page reflects the I can see coming at me. These are the things we need to know about why notices are so important.